Good afternoon, good morning, good evening, whatever time it is right now. Today we are going to discuss probate real estate process. Thank you so much for joining me. Hello, how you doing? I am so glad that you came. Today you are going to learn what you can expect during the probate real estate process from beginning all the way to the end. So guys, be sure to stay tuned to the end of this video. I have made some links at the bottom so that if you're in a hurry and you just want to know a particular piece about this process, for instance, if you want to know what's to know about the notice to creditors, you'll see a link below this video so you can kind of skip on to that. But I recommend that you watch this entire video if you have time. Alright guys, so my name is Felicia Terry. I am a probate specialist here in the Georgia state, in the state of Georgia. I am also a real estate agent, so if you're looking to do anything real estate wise, I can assist you with that just as well. But today we are here to discuss what you can expect during the probate real estate process. In case someone didn't properly plan during the estate planning process, or if they didn't even do any estate planning, you definitely want to watch this video. If you are the executor of an estate, you want to watch this video. If one of your loved ones passed away and unfortunately did not have a trust, then this video is for you. So just stay tuned, and hopefully when you're done with this video, you'll have a better idea of what you can expect during the probate real estate process. Now, I must give you this disclaimer, and I'm going to put it on the video just as well so that you can read it. But this disclaimer is that I am not an attorney. I am not a real estate attorney. So please be sure to contact your local real estate attorney in Georgia or whatever state you're in so that they can assist you with lawyer questions. Okay, this is just to give you an idea of what you can expect during the probate real estate process. Okay, all right. So first step is filing the petition, and you'll probably see me look down a little bit because yes, I did take notes. Okay, a good leader will take notes so that they can provide you great information, not straight from the head. Okay, the first step with an estate is to file a petition with the court. This includes a copy of the death certificate and the will. The court will review the petition and other documents to open the probate. At this point, it will determine who should be appointed executor. If the will names someone as executor, also known as administrator or personal representative, depending on which state you're in, the court will most likely approve that person. Sorry. If no one is named, or if the person named is unable or unwilling to act as executor, the court must appoint someone else. While it may be one of the beneficiaries, an attorney or accountant for the estate may also be chosen if none of the heirs want the task. Okay, and if you're going through it as an executor right now, then you kind of know why someone would not want to be the executor, right? Number two, issue bond. What is the bond for? Okay, so the executor will need to get a probate bond to protect them from any claims made against them for fraudulent activity. This bond is a surety bond to cover the work they do on behalf of the estate. If they should make a mistake that costs money to the estate or the heirs, the bond would cover them. When the person is approved or chosen by the court, they are given documents called letters of administrator or letters testamentary. These documents show they are allowed to act as managers of the estate. This gives them the authority to pay bills, sell assets, and do other tasks as executor or administrator. Okay, so that's number two of the process. Now number three is the notice to the creditors. Once a person has been named as executor or administrator, one of their jobs is to give notice to creditors. The exact process will vary by state. Sometimes a person simply publishes a notice in the local newspaper. Other times, they are also required to send letters to the known creditors. The creditors are given a certain time frame to submit claims to be paid. Generally, they have about 3 to 4 months to do so, but this time can vary by state. And of course, if you're watching this video right now in April or March of 2021, then you know that there's COVID-19 going on and all this other thing. So depending on what is going on, it could be a little bit more time just as well, okay? Number 4, take inventory. Oh, this is the fun part, right? Take inventory. This is where the executor, while the executor is waiting to hear from the creditors, they'll be taking inventory of all the assets owned by the deceased. In a small estate, this could take only a couple of days. In a large estate, it could last for several months. The executor must track down all assets and get proof of ownership. They must secure the assets to ensure none are lost, stolen, or sold during this time. They may need to sell some of the assets to pay the creditors. If the deceased person owned a business, it may need to be closed to allow for liquidation. This process can take quite a bit of time. All right. So now that you're waiting to hear from the creditors, you're taking down the inventory. Okay. My mom had a house. She had a car. She had this. She had that. I know she had, a house in New York. So all of these things, you want to make sure that you're taking inventory. This is where you're also going to find out the fair market value. Usually you can find that online. Okay, so you want to make sure that you have these things so that way the judge can have an idea of what the estate is valued at, right? And as it said here, depending on what is owed to the creditors, you may be required to sell the property. I know sometimes people don't want to sell the property. Okay, maybe it's a family-owned property that you want to keep. Then you may have to end up paying some of the creditors out of pocket so that you can avoid paying or selling the property. Okay. Number 5, pay estate taxes. The next task is to pay the estate taxes. The executor will need to file personal or business tax returns if necessary and pay any amounts owed. This task must be completed before the estate can be distributed. They will need to wait for the returns to be approved to ensure no changes are made. Now, most of my clients that are dealing with this, they hate it. They hate it. As a matter of fact,
all of them do.
No one wants to deal with, we don't even want to deal with our own taxes. Now we got to deal with the probate estate taxes. OMG, right? So the quicker you liquidate the estate, the less you have to deal with that stuff. Because as long as you have property, then you're going to have to file taxes on those estates, okay? On those properties. And again, everything that I'm sharing with you is coming from a probate specialist, a real estate agent's standpoint, okay? This comes from me studying. So anything that I'm telling you, please make sure you consult with an attorney, especially if you are not in the state of Georgia, okay? But always consult with an attorney first, okay? Number 6, final petition for final distribution. Once all the other tasks are completed, the executor is responsible for distributing the rest of the estate to the heirs. This can be as simple as issuing funds for each person. It can be more complicated if the will stipulated for the transfer of non-liquid assets. For instance, the deceased person may have given their home to one of their children. The title must be transferred now to the new owner, which is the job of who? The executor to oversee. Okay? So as you can see, a lot kind of falls onto the executor. But if you have someone in your back pocket, like me as your probate specialist, and I can kind of help you through that process if I don't know everything. I always tell people, hey, you know, I don't know everything, but I do know a lot because I've been handling these cases for years now. The real estate side of things, okay? I am not an attorney, but hey, if you ask me a question that I cannot answer, then I'll direct you to the right person. Whether it be, if it's a legal question, of course, you know, to go to the attorney. All right, but for certain things, if this is not my lane, then I will refer you to someone that can help you, or I'll show you how you can get to a person that can help you with that, okay? How long do you have to file probate after death? There are a lot of deadlines to deal with when it comes to probate. The first concern for many is how long they have after someone dies to file probate. The answer varies by state and can be a little complicated. The will must be filed with the court in a timely manner, even if there's no petition to file probate at that time. In Florida, the will must be placed with the court within 10 days from the notice of death. In California, you are given 30 days to file that will. This is a good time to file for probate as well, but you generally have more time for the petition than you do the will. Each state and even the counties within the state can set their own rules, but the general guideline is to file within 4 years of the person's death. Now, again, I want you, when I say this, I want you to finish the video and then go and consult with an attorney. If you have a trust, that's how you can avoid probate. If your family member didn't die with the trust, they only had a will, or they did not have a will at all, then unfortunately, in order to liquidate the assets, or really to do anything with the assets, you're gonna have to file probate. I'm working with a young lady now who wants to get the property refinanced, wants to keep the property, but she can't do anything right now because she's going through probate. And unfortunately, in the meantime, the property is facing foreclosure. Okay, so that happens quite often, believe it or not. And you know, so that's why it's important to go ahead and, you know, every time you complete one step, go to the next step. You know, keep going until you're done, because if you don't, then your family's property could possibly get taken away, and God knows no one wants that to happen. What happens after probate is closed? Once probate is closed, the executor's job is done. Finito. Finished. Yes. Any involved parties do have up to 6 months to object to the proceedings. They can sue the executor or file an objection for the actions of the executor or administrator. If the estate wasn't closed correctly, this timeline may extend to 3 years. The most probably reason that the parties would object is if they claim the executor made an illegal or even just an unfair decision during the probate process. Another issue is if the assets are discovered after probate has been closed. Another issue is if assets are discovered after probate has been closed. Okay, so maybe found out that Sally Sue had another, 2 acres of land in another county that we didn't know about. So then they would have to reopen the case, right? Petition must be filed with the court for these assets to be handled according to the will. Okay? Before taking on responsibility as an executor, before you agree to take on the responsibility of being an executor for an estate, you need to think about what it will mean. Okay? Remember I told you it's kind of difficult? If the estate is large and complicated with multiple heirs, you may have a great deal of work to do. Plan to spend hours upon hours working on the task of that estate. It can be like having another job. If you already work full-time or take care of kids, you may not have the time or energy to devote to this task. It can be a very, very daunting task, guys. Trust me, I've been through it myself. It's not fun. It's not easy. Everybody want to be the executor until it's time to be the executor. And then you got some people that had no clue that someone was making them the executor of their will. They just surprised, hey, here's the will, you know, you were named the executor. We need you to fulfill this job. But anyway, another issue to consider is how you get along with the heirs. Many times, the person chosen is an heir, and you have to think about how the others will see your actions. What you must do must be above reproach. If you don't get along with the other heirs, probating the estate can compound the problem. Trust me, I know. Before you decide to accept the role of administrator or executor for an estate, make sure you understand what is expected of you. You will have deadlines to meet, tasks to perform, and laws to follow. Working with a probate attorney could make the job easier, or a probate specialist. But in the end, the responsibility is yours, okay? So guys, that is the probate process. That is what you can expect during the probate process. So if you're watching this video and you are not there yet, then you want to make sure you do some proper estate planning so that your family can hopefully avoid having to go through the entire probate process, okay? Things like when you set up a revocable living trust, again, consult with your attorney. I have to keep saying that, you know, because some people want to be like, oh, I thought she was an attorney. No, I'm not an attorney. When you're setting up your revocable trust, you don't have to go through probate. You don't have to go through probate typically, okay? Those things are already taken care of within the trust, guys. It's a beautiful thing. So make sure you, again, reach out to your local attorney, ask them about that. Listen, thank you so much for taking the time to watch this video. If you have not already subscribed to my channel, please make sure you go ahead and subscribe. Click the like button. Comment below if you have any questions. I usually turn my ringer off. I did not this time. Anyway, I have to go, guys. Take care, and I'll see you on the next video. Bye-bye for now.